Hello, Your Honor, and hello, Matt. How are you guys doing today?
Fine, thanks.
We're great, thanks.
So, both of you are well known in the world of criminal law, especially in Ontario. I don't feel like I need to make any introductions. I mean, Your Honor, you're a judge at the Ontario Court of Justice in Toronto, downtown Toronto, 10 Armory. Before that, you were working as an assistant crown attorney. And now you're giving all these really good decisions, I think, personally, very beneficial to the defense. For many of them, some of them I really disagree with the decision, but but I find they're really fair. And Matt, you're a very well-known criminal defense lawyer. You've been practicing, you're a senior now, and you've been practicing for many years, and you've been before all levels of courts. And your work is primarily in criminal defense.
Correct.
And both of you, the reason why you're here is because you're going to be talking to us about evidence. And this is more like a refresher or an update, more like an update on the law of evidence. You both co-authored a first edition of the evidence law book from Emond Publishing. That was a very successful book, and it's a more modern take on the law of evidence. But recently, and this year, actually, it was just like a few months ago in June, I believe,
July.
that or July. Sorry, it was in July that the second edition came out, and it's significantly more voluminous, reflecting how many more changes there are now in the law of evidence. So we wanted to talk about that because it's important, I think, for people to get all these updates. So before we do that, though, if you both can explain what was the reason behind the second edition? What drove you to come up with the second edition?
Well, a lot has changed, to be frank, right? Like it's hard to stay on top of all of these developments in the law. Parliament updates the criminal code. Major decisions are released all the time from the Supreme Court or various appellate courts and trial courts, obviously across the country. I know it's tough for lawyers to keep up with all of these changes, but it's important for all of us to stay on top of this, but also to have it, quite frankly, synthesized in a way that makes it comprehensible and easy to use. And that's really one of the goals of the text, right? To take all this material, to give you the core points that matter, but also hopefully to present it in a way that makes it a little easier to read and also a little easier to apply when you're actually in court. You have to make sense of, well, what do all these heavy decisions mean? How do I really effectively use them in court? Maybe for submissions, for how you ask a witness questions, etc. So it's a never-ending, I guess, challenge to keep up with all these developments. But I actually really like it. I find it's really intellectually rewarding. And writing the update to the book was fantastic because we were able to go over all this, get smarter ourselves, work with each other. It's just a great team. And anyway, I'm quite proud of the finished product.
Yeah, and I'd like to also acknowledge our co-author because we're not the only
Of
authors of
course.
this book. We wrote it with Justice Rennie Pomerantz from the Court of Appeal, Glenn Crisp from the Crown Attorney's Office, and Jill Makepeace from Greenspan Humphrey Makepeace, another criminal defense lawyer, and my colleague at the bar. And everyone made huge contributions both to the first and the second edition. With the first edition came out in early 2022. And this, as you've said, Maya, came out just last month. So we've had essentially four additional years of legal developments to incorporate into this new edition. So there's new law in it. We've also rethought to some extent, our approach to the material that we presented in the first edition and tried to reformulate it in a way that made the most sense for practitioners and judges. Because the way we sort of conceptualize this text is as a real resource that lawyers and judges can go to in the midst of a trial for concise and practical guidance on how to deal with tricky evidentiary issues. So, we certainly, there's lots of good evidence textbooks out there. There's lots of, the mainstays of the genre, which include the old Sapinka text and Justice Pachaco's excellent text as well. The way that we see ours making a contribution is that it's specifically geared to criminal evidence. So it's very much intended for the criminal practitioner and the criminal court judge. And we've tried to take a practical approach that gives people tips about how to handle these issues on the ground. And we've filled the text with practical tips that hopefully are of use both to Crown Counsel and defense counsel as they negotiate these issues, which can sometimes, arise on the fly in the course of a trial. And, you need to have that ready guidance on how to handle it. And, even in the age of AI research, there's no substitute for a concise and authoritative text, in my view.
Thank you. And yes, so those are really important reasons to have this update. And because as you mentioned, the first edition was like a few years ago. It was in early 2022. That was soon after COVID, and things have really changed since then, the practice of law and the law itself. So what are some of the main or the big topics that are dominating right now in the law of evidence?
Man, that's a big question.
Some of the more interesting or the more
Okay.
The newer ones.
Sure. Well, I'll tell you, one of the areas that I find just fascinating is digital evidence, right? The provisions in the Canada Evidence Act that deal with the authentication of digital evidence and what that means as a matter of law were drafted back around the year 2000, right? They haven't been meaningfully updated in a long time. The technology has just changed so much. We all see it in our personal lives, obviously, everything from our phones to other devices, just to how we deal with day-to-day activities. But in court, we're having all kinds of really interesting developments occur as a result of this. The primary one, of course, is what Matt already alluded to, which is, the use of AI now, and of course, deep fakes or potentially false or fraudulent electronic evidence. So how do we stay on top of that? Does the legislation still give us the parameters necessary to properly and safely, quote, authenticate digital evidence? And you see this creeping into the case law a bit now, too. There's a really interesting decision from the Ontario Court of Appeal called Aslami that's in the book that we talk about, and then some cases since then that have tried to deal with it. And as a judge, I can tell you, I'm already experiencing some self-represented people raising with me, look, maybe all this digital evidence is, quote, a deep fake, Your Honor. Can courts take judicial notice of that? How can we make sure the proceedings are still fair for someone who maybe can't afford an expert or otherwise challenge the evidence that the Crown wants to use against them? There are a lot of really fascinating issues that arise out of this that are focused on just that, the law of evidence. So we expanded the digital evidence chapter considerably. We put in a whole new section on the rise of this technology with some suggestions to counsel and courts on how they can hopefully deal with it. I hope it's helpful. I mean, this is an area that's going to be changing so much, and sooner or later, I'm sure we're going to get a very interesting appellate decision on this. But I hope, at least for now, it provides some food for thought and some guidance to counsel about how to handle these voir dires, what you should be looking for, and when expert testimony is or isn't required.
It's interesting to me that when the sections of the Canada Evidence Act dealing with digital evidence were enacted all those years ago, digital evidence was really the exception. Something is an exotic kind of evidence that was increasingly coming into some trials. Now digital evidence is the norm. Most of the evidence we have in many cases at least, is digital in the sense that the very broad sense in which the Act uses that term, which is anything that arises from a computer device of any kind. So, there's rarely a trial nowadays in which text messages, social media messages, emails, that there's rarely a trial where those don't come in evidence in some way. And are the legal tools that we have to deal with them were devised in a day where there really there wasn't any kind of realistic concern, or at least in most cases, there wasn't a realistic concern that these things could be faked, at least by the ordinary person. There was an interesting article in the Toronto Star by Betsy Powell just last week about a really scary case, I think it arose in Peel, where an accused person had been held without bail for many months and then was subsequently on a strict release as a result of charges that ended up withdrawn by the Crown once the Crown was satisfied that the Facebook messages that had given rise to the charge were completely faked. I don't know in that case whether or not it was an application of deep fake technology per se, or some cruder effort by this witness to set the accused up. But in any event, they were good enough fakes to fool the police and the Crown prosecutors for many months while this innocent person languished in jail. And so that case provided, it's a very worthwhile article for people to check out, because it provided a real case study in the dangers of too readily accepting the authenticity of electronic evidence that is increasingly easier to fake. There's a problem on the other side as well, and we deal with this in the book also, which is the danger of genuine evidence being wrongly discounted because of this general risk of fakery. And that's something that we can't lose sight of as well, because ultimately we're in the business of seeking the truth about things. And, historically, some of the best ways to get at the truth have involved video evidence, photographic evidence, and other kinds of what are now digital forms of evidence. And if we can't believe our eyes about what these forms of evidence, what kind of proof they entail, we're in a pretty scary place. So we have on the one hand this real increasing risk of wrongful conviction ultimately based on potentially fake evidence. But we have on the other side, a risk of simply not getting to the truth of the matter, maybe wrongful acquittals, maybe mistakes of other kinds that result from this general inability to separate the real from the fake. And the courts are going to need to, and lawyers are going to need to figure out how to handle that. Now, partly it's through increased use of computer forensic expert evidence. But as Justice Jones has pointed out, that's not a panacea. First of all, because not every case has the resources attached to it to engage that expertise. So I hope that our chapter in this edition of the book will at least provide some guidance to lawyers and judges as they start to grapple with these issues. And I'm sure when the next edition comes around in a few years, that chapter will be considerably longer and more detailed.
For sure. This is definitely becoming a more and more challenging area of the law, because there's more and more digital evidence. It's becoming the norm. As you mentioned, Matt, it's almost impossible now to have a case without any kind of digital evidence. The challenge now, though, is that when before this was considered to be the best evidence, it's independent, it's not a hearsay, he said, she said kind of thing. Now even that is questionable, which is adding more expenses, but also more time. And time is also becoming a problem now, that this requires more time in court, more applications and more checks and more work. But this is definitely a very important new development in the law, and it has considerably changed in the past, I would say 3 or 4 years. But there are other major changes as well. There's the Corbett applications, Matt. I know that you wanted to talk about that because there were some recent developments and important cases on that subject. So maybe if you can give us an update.
Sure. Well, this is in one of the chapters that I was primarily responsible for, a chapter on character evidence. And I think it was the most recent Supreme Court case that we managed to get into this edition, because at some point we had to go to press and we couldn't keep including cases decided in 2026. But there was a case decided in early 2026 called Hussein, which, as you said, Maya, deals with what we call Corbett applications. And so what's a Corbett application? To review, it arises when you have an accused who wishes to testify. The accused has a criminal record. And Section 12 of the Canada Evidence Act says that any witness can be cross-examined on their criminal record. Corbett was the case that said yes, but the judge has a discretion to curtail or limit or prevent the Crown from cross-examining the accused on his criminal record where it would undermine trial fairness. And Corbett lays out a certain set of factors for determining when that Corbett application should be granted, when the accused's criminal record should either be excluded from evidence or edited. That decision was rendered in 1988, and in the many years since then, there's been a lot of commentary about how it has been inconsistent in its application. So it would be very difficult to predict, if you have a client with a criminal record, if the record would be admitted into evidence, if it would be edited, and in what respects it could be edited. A lot of contradictory cases had entered the jurisprudence in terms of whether a violent record was relevant to the accused's testimonial honesty, whether certain factors like the social circumstances in which the record was accumulated, whether they should be considered in determining whether the record should go in front of the jury. And so this was, in my view, ripe for reconsideration. And I was the lawyer for Mr. Hussein in the Court of Appeal, and then in the Supreme Court of Canada. We argued first in the Court of Appeal that Mr. Hussein's criminal record in his trial for murder should have been excluded, and the trial judge disagreed. The trial judge admitted his entire criminal record, which did have a number of violent offenses on it. Mr. Hussein was convicted of murder, and our appeal in the Court of Appeal was dismissed. We used the existence of these contradictory trends in the Corbett jurisprudence to persuade the Supreme Court to grant leave to reconsider Corbett. And what they ultimately did in their decision released earlier this year was interesting, because while they reaffirmed Corbett in certain respects, and they purported to be reaffirming its core holdings, they did, in my view, innovate the doctrine in certain important ways, and I think made it easier for defense counsel to argue for exclusion of a criminal record, especially where the criminal record is of non-honesty related offenses. So obviously, if you've got a client who's got a record for fraud or perjury or even breach of court order, the Crown will have probably a good argument that those convictions are relevant to the accused's testimonial credibility, and it should be fair game for cross-examination. But if your client, let's say, is charged with a murder and has a record for assaults, of course, the risk is that the jury will use those prior convictions not to assess the accused's testimonial honesty, but to ascribe to him a propensity for violence. And that's that propensity, that bad character inference, is precisely the one that the law doesn't permit. So in Chief Justice Wagner's majority decision in Hussein, he recognizes that risk. I think he gives a very strong account of the prejudice attached to having a criminal record of the accused in front of the jury, and he gives the defense a lot of tools to use to persuade a judge to exclude a record. And I think it'll produce more consistency in the law going forward. I think counsel should have regard to the decision, not just in the traditional context of jury trials, where you're trying to shield the jury from even knowing about the record, but also in judge-alone trials, because obviously you can't the judge has to see the record in order to determine whether it's relevant or not. So you're not going to keep the judge in the dark about the record. But you can, I think it's worth making the judge self-conscious about what inferences can or cannot be drawn from any cross-examination that does take place on the record, because ultimately the judge is going to have to write reasons articulating why they do accept the accused testimony or don't accept the accused testimony. If the accused record is before them, that's going to play a role. And Hussein has important things to say about what lines of reasoning are and are not legitimate. So we do have a significant section of the character evidence chapter of the book that reviews Hussein and gives counsel some tips going forward on how to use it. And I think it's one that lawyers are going to want to pay attention to.
Right. There's something in that case too that I think can be used more broadly, which is sort of shaping the law of evidence in this country in ways that aren't always immediately apparent, but it's creeping around, which is the use of social context evidence. Like in Hussein, as I understand the decision, there's a lot there that talks about not every conviction should be viewed the same way because of the life circumstances of the person who was before the trial court. Similar to what the Ontario Court of Appeal decided in a case called King with an Indigenous accused person. And the courts have to be alive to the reality of what many disadvantaged Canadians have experienced, and maybe an accumulation of certain convictions isn't necessarily a sign of dishonesty, as much as it might also be a sign of just having had a difficult life with a lot of interactions with the criminal justice system one way or another. And then the Corbett analysis can be tailored appropriately. Obviously, that's directly relevant to those applications. But how social context evidence is sort of affecting the law of evidence more broadly, I think is really quite fascinating. In a youth sentencing decision called IM that came out last year, it was considered to be extremely relevant to assessing a young person's moral culpability. You can see it applied in adult sentencing decisions now with what evidence is relevant there or not. And there's some other examples that have started to explode too. So I often say, when I do these CPD events in general, look, if you have a client where this might be relevant, it is entirely appropriate to explore this. And it gives me better information to make a better decision at the end of the day with whatever application or whatnot I have to decide. And I hope we've done a good job in the book exploring this in the areas where we have something to work with. But I can see this, again, being something that becomes very interesting in the future in a lot of areas.
I think one of the things that it's important about Hussein is the insight that you mentioned, Brock, that not all convictions are created equal, and where you have an accused from a disadvantaged background with even a lengthy record that's full of breaches of court orders, guilty pleas to those kinds of offenses. It may not be so accurate to say, to invoke the traditional view that this is an accused with disdain for the justice system, who's not to be trusted and all of this stuff. It may be somebody whose record is really the product of disadvantage and perhaps less than excellent representation, more than mendacity or antisocial personality. And
Sorry.
Go ahead.
The circumstances can be very different. Like, for instance, if we're dealing with a female accused who has a record, let's say, for assault, and one of them is in a domestic context, and then another one is just on a stranger, let's say, in a bar, the dynamic is very different in a domestic violence context. So what would make a female, for example, assault her partner is just very different. And that understanding is really important. We cannot compare the two. It doesn't necessarily mean that she's violent for the same reasons or in the same circumstances. So it is, I agree that it is important as well to be mindful of the fact that these convictions don't happen in a vacuum. There are circumstances. They're really important to understand. And it is important to shield and protect them from having an impact on assessing the character of the accused. And I can't help but make the comparison. It's in a different context, but when we look at the warrants that we get or the ITOs of CIs, I mean, we hardly get any information about their past convictions when it could actually be very relevant for the defense. And it's so hard to get any kind of information about them. And yet the person who's accused, it's much easier to get all
Sure.
kind of
They
information.
made one of the arguments I made in Hussein, which I hope sort of resonated in the judgment itself, is that when we remove barriers to an accused telling the court their side of the story, especially barriers that fall disproportionately on certain disadvantaged groups than others, and certainly the criminal records do, we enhance the truth-seeking process. So I hope that one of the outcomes of that decision may be that more accused who might have been disinclined and disincentivized to testify in the past may not be now, and I think that will improve the quality of our trials.
That's true. And this is really a very important and interesting development in the law. Now, if we move on to another topic, there's also the area of confessions. That was one of the topics that we wanted to cover. It's also part of the book, but so what can you guys tell us about this area of the law?
Well, it's an area that you think might have been settled by now, but you never know what kind of developments can come along when you get an interesting series of cases like we did in the last few years. So, for example, we had the Tessier decision from the Supreme Court of Canada in 2022. Does it matter that the police don't caution someone when they're going to be questioned, especially if they are a suspect or not? What rules are triggered there, or how should the voluntariness voir dire be conducted or assessed possibly differently than in a more classic case where someone's just formally under arrest, obviously, and hopefully given the right to counsel and whatnot. I think that it was very interesting when you see the differences between the majority and the dissent in that decision about what the absence of a police caution means or not, whether it should be automatically fatal, so to speak, to the admissibility of the statement, how the different analysis is approached, and some interesting tools in there about how to determine is someone, quote, a suspect or not for criminal law purposes, and how we would accept the need for such a voir dire. Something that is extremely important for everyone to know now. In those cases, perhaps when your client at the time they were talking to the police wasn't formally under arrest yet, and how the court looked at that. And then in another really interesting decision released that same year called La France, you have another case dealing with the admissibility potentially of a statement that focuses on, at least in part, the fact that Mr. Lafrance was an Indigenous Canadian and how that should be factored into how he would have perceived his interactions with the police, whether or not he was detained, perhaps how the right to counsel should be evaluated. All of this, again, is building on classic areas of law that we all learn in law school, and that you think, well, I learned about Oikle 20 years ago, right? So I know everything. Well, no, that's a good start, right? But you've always got to keep looking for the developments. And we've weaved this into the book, obviously, and tried to expand those portions of the chapters that are relevant, again, to hopefully give people a synthesis of all of this information and the tools to effectively make the right arguments. And I hope without being overwhelmed by what I know is a lot of important Supreme Court cases that seem to keep coming out every year.
There was an interesting, aside from those important confessions cases from the Supreme Court in the last 4 or 5 years, there's been some interesting cases in the Court of Appeal as well. I think of the Chief Justice Tulloch's decision in the Emond case, which was a sort of a Mr. Big style scenario. We know those cases from Hart onwards, which involve the police going undercover and pretending to be criminals who insinuate themselves into the suspect's social circle and try to prompt a confession, usually to a cold case that's under investigation. And what Chief Justice Tulloch talks about in the Emond decision is circumstances in which the rule from Hart, which is about the admissibility of Mr. Big confessions, overlaps with the rule in Handy, which is about prior discreditable conduct of the accused. So what do you do if you've got the accused engaging in all this discreditable conduct in the course of a Mr. Big operation? Do you apply just the Hart test to the admissibility of the ultimate confession, or do you apply Handy to all the stuff that leads up to the confession? Usually involves the accused doing some pretty unsavory things with all these pretend criminals. And Chief Justice Tulloch says, well, you have to apply both, actually, because you can't allow all of this discreditable conduct evidence to go in just because it ultimately produces a confession without screening it through the Handy regime. So that's an example of the way in which two doctrines that we thought were kind of separate in the law of evidence have merged in interesting, or overlapped in interesting ways in the last few years. So yes, the law of evidence is always changing, even when we're dealing with principles going back 100 years. There are always new factual circumstances that can produce some doctrinal change that lawyers need to keep on top of.
Now, I'm moving on to an area that keeps changing and is becoming extremely more complex and challenging and a disaster for defense lawyers, and that's the area of sexual assaults. Like there have been some major changes in this area, and it continues. I mean, God knows what's going to happen and whatever is left this year and the coming years, but it's becoming more and more difficult, lengthier, more and more applications. So let's talk a bit more about some of these recent developments in this particular area.
Right. So people obviously have written entire books in this particular area of the law, given how complex it is. We don't do that, of course, but we do have some portions of the book that deal with changes in the law of evidence vis-a-vis, especially the questioning of complainants about prior sexual activity or private records already in the possession of the defense. So we reviewed JJ and how that case sort of dealt with the legislation and how it should be applied now. And then we've looked at some other developments since then in this area of the law more broadly. I mean, there's so many cases, we couldn't mention them all right now, but some of the big ones would include RVTWW from 2024, talking again about the test for admissibility of this type of evidence and how high the standard may be for defense counsel to succeed in one of these applications. Kinnamore in 2025. Which started off, I think, in the opening paragraph with an acknowledgement by the Supreme Court about how complicated this area has become. Time will tell if we've done any better to make it less complicated, as Parliament also keeps getting involved with legislative changes. It's hard to make this comprehensible at times, I appreciate, but in the book, again, at least we've given you the core needs I think you would want to look at for these changes, a little bit of advice about how to pursue this properly and ask the right questions and prepare your materials effectively so that your applications are more likely to have a good chance of success on the merits, what to contemplate perhaps in response, and just generally how to get your head around all of this. Although this is admittedly an area that may take a great deal of study and particular nuance and appreciation for what's different in sexual assault cases. I know there's one well-known evidence professor out there who calls it sort of the black hole of sexual assault law, and how many of the rules that you would standardly apply are very different in these cases. But all we can do is do our best regularly and try to stay up with the changes. And I hope, again, at least we've put the big ones in there, given you the tools you need, and help put you on the right foot.
Yeah, I mean, it used to be that the one sort of highly technical, specialized area of criminal law was impaired driving and over 80. And now I would certainly include sexual assault in that category, where you shouldn't approach one of these cases unless you have a thorough grounding in the specific statutory and common law rules that apply to the admissibility and use of evidence in these prosecutions. And I think you've touched on the principal cases. Obviously, JJ is the most important one in the last decade, but Kinnamore, just from last year, is hugely important as well. And it as a common law development, thoroughly extended the Section 276 statutory regime, which by its terms only applies to defense-led evidence, it extended it to all Crown-led evidence of this kind as well. Since then, lo and behold, Parliament has come in and codified the Kinnamore common law doctrine, and this will, I assume, be a major item in our next edition of the book, because those amendments have come in as of just last month and are going to be effective at different times and then going forward in the next year. I'm talking about Bill C-16, of course. It affects much more than just sexual assault prosecutions, but the Section 276 and 278 regimes have been thoroughly reformulated, redrafted. And the substance doesn't change a lot, but the organization and numbering of the provisions does change. And so lawyers are going to have to get their head around those changes as well. Unfortunately, we didn't have time to. They're not going to be in this edition, but as I said, they largely enact the Kinnamore changes to the law. So if you get your head around that decision, you'll be most of the way there.
And of course, I mean, like the double nightmare in sexual assault cases is, first of all, when you have digital evidence, you want to decide, like, if they're records, if you can't, what can you have admitted, if it can be admissible or not, to what extent, and then if it's fake or not. So it's just like a lot of work and a lot of confusion. And these types of cases have also become a little bit different from regular criminal cases, in that the complainants have a right to have a lawyer present at parts of the proceedings, like evidence that we usually can use without asking for permission in another trial. It's different here because of JJ and Kinnamore. Like
absolutely. I mean, the one universal lesson that I think is valid is that you have to look at these things early and be aware that you're going to have to negotiate these statutory rules of admissibility in lots of cases where you wouldn't have to if it were a non-sexual prosecution. So you're going to have to scrutinize defense evidence with an eye to whether or not it is a record under the terms of the statute. And if it plausibly is, you're going to need to address that and bring the necessary application. And if you don't, you're going to get into a lot of difficulty.
And of course, there are some strategic points that come into play, because obviously with every one of these applications, there's more information that can be revealed on the part of the defense. So it's a strategic decision on the defense lawyer as to the timing as well, how they want to reveal and when. So these are all things that are new considerations, or that we're having more and more to do. So if we move on to the other area that is also a bit unique here, it's the intersection of proceedings, of criminal and civil and other, like, family proceedings. So this is something that we don't usually know much about and we don't hear about, but we're seeing more and more of this intersection of various types of proceedings. So can we talk a little bit about this?
Yeah, look, I think this is just a really great chapter that we included in the first edition, and then we improved greatly for the second edition. Full credit goes to some of the extra contributors who gave us a hand with this. A brilliant young associate at Matt's firm named Tara helped a lot. I was sort of the chief architect for this chapter. A family lawyer named Christine Ashbourne, who also contributed greatly. They made it such a difference because we had people who live in this world offering their perspective and knowledge about what matters. But what do you do, right, when you have a client maybe that has a civil proceeding ongoing and criminal charges, or a family proceeding ongoing and criminal charges? How does the law of evidence work? What if you want to rely upon something from one of those other proceedings in the criminal case? Well, can you do that lawfully, and what value might it have or not? Can the Crown rely on something that occurred in a civil or family case if they happen to get wind of it? If, say, they wanted to cross-examine your clients, should your client choose to testify in a criminal trial? So, of course, we look at some of the most important areas like Section 13 of the Charter and Section 5 of the Canada Evidence Act. We look at the Ontario Evidence Act and how that can be applied depending on what happened in criminal court. vis-a-vis civil, family, and even immigration proceedings. We look at it, I hope, on a practical level as best we can, covering the core areas about what lawful uses somebody can or cannot make of evidence obtained in another proceeding when you're also overlapping with a criminal proceeding. And this is an area that I'm sure will only continue to become more interesting and probably more complex. The Supreme Court now just decided the Ahluwalia decision in family law, which allows for an independent tort for, coercive control. Well, what does that mean potentially, depending on a criminal case outcome? If your client is convicted in criminal court, what would that now potentially mean in family court or vice versa? How can all of this be handled properly and effectively? What at least should you be thinking about as counsel when you're dealing with it? And what should I have to think about as the judge or hear submissions on about the admissibility and lawful use of evidence potentially obtained in another proceeding before I permit it to be used for any purpose whatsoever in criminal court? I see this already in some cases. I had a decision recently where what was going on in family court was attempted to be used to assess the credibility of witnesses in a criminal trial. It's something that I think many of us, as we get, how shall we say, experienced in one area, maybe lose sight of other areas. But you have to understand how these interactions work, certainly at a high level, at least. And I hope within the chapter we've given you the tools to find out what you need to know. And then if you have to do a further deep dive, to go on from there.
Yeah, I think a lot of it is as a criminal lawyer, just becoming sensitized to these points of interaction and knowing where an issue is likely to arise, to be so that you're not walking into a trap or something where you're exposing your client to disadvantage in another forum when there's parallel litigation. And sometimes, it'll be no more than recognizing the issue and sending the client off to get expert subject matter advice in the other area. Sometimes it'll be working with counsel in the family proceeding or in the immigration proceeding cooperatively in order to make sure that that the client's interests are being properly protected in both. And so I think this chapter we go through overlap with civil proceedings, with family proceedings, and with immigration proceedings, and give criminal counsel, primarily defense counsel, of course, in this context, some of the tools they need to recognize where these landmines might be and where they need to really be alert to potential problems and either direct the client in the right direction or have a cooperative relationship with counsel in the other proceeding. Because what you don't want to do is walk into something that can be a problem both for the client and for you potentially if you are, for instance, just handing over a Crown disclosure to a civil lawyer that's defending the client in a civil suit without understanding the legal regime that applies and the restrictions that apply in both proceedings to using material like that. So I hope that this chapter is useful for practitioners to spot those issues and keep themselves and their clients out of trouble.
And I have to add one thing, which is just not necessarily the intersection of other areas of law, but sort of an intersection of two types of criminal law. We also touch in the book about how the youth and adult criminal justice systems can interact at times. And in particular, if you want to use youth records for any purpose, how that can be done lawfully too. There is another book on that subject as well in the same series, but nevertheless, it's in here as well. And that is something I do see, quite frankly, regularly, even within criminal litigation. And, it's important to remain abreast of all of those developments in the law there too.
Yes, and on that point of the youth and adult, I mean, that's really important for many of the youth clients who continue on the path of criminality into adulthood, and they have a youth record. Crowns will want to use that, and sometimes Crowns, without being aware of the fact that there are some restrictions on that. I mean, I've had that experience recently, and it's really very important to protect those youth records. So I don't want to take much of your time, but we can cover one bonus point. Matt, I think there's also something that you have contributed to in the book, and it's about judicial notice. So if we can talk also about that, because that's in the book as well, and there have been some updates in this area. If we can talk about that.
Sure. So the chapter on judicial notice, which really is proof without evidence, and sort of the exception to everything else in the book, which involves actually proving things through admissible evidence. Judicial notice is what facts can be found without any evidence of tendered before the court, just through the judge's own indisputable findings about how the world works. There's a lot of overlap between the doctrine of judicial notice and a very hot topic in the sexual assault prosecution world in the last few years, which is this idea of myths, stereotypes, generalizations, and how they're used in the fact-finding process. Obviously, we've had many years of being educated about myths and inappropriate myths and stereotypes in relation to complainants, many of which are now statutorily barred and covered by Section 276. But we've also, in more recent years, had a lot of attention paid to what you do about inappropriate generalizations about accused people, and how that can also compromise the integrity of the fact-finding process. And in the last edition, we talked a lot about the decision of the Ontario Court of Appeal in a case called JC, written by Justice Pacheco, and a case from the BC Court of Appeal called Roth, which attempted to set down some guidelines which would distinguish appropriate use of common sense reasoning from inappropriate reliance on generalizations. Since the first edition, we had the Supreme Court's decision in 2024 in a case called Kruk, which overruled a lot of that previous authority that we talked about in the first edition. It explicitly overruled parts of JC and Roth, and said that there is no equivalent doctrine to the complainant myths and stereotypes doctrine as it applies to accused people, and that the myths and stereotypes we've recognized as prejudicial to complainants are kind of sui generis, resulting from a history of poor treatment and discrimination against complainants, and that there's when we can't just apply an equivalent doctrine to pick apart findings, credibility findings by a trial judge against an accused person. It's not good enough to simply say that a trial judge relied on inappropriate generalizations against an accused person. You've got to show that the trial judge actually made a palpable and overriding error. And reliance on common sense in fact-finding is not permitted. In fact, it's necessary and to be and encouraged. So Kruk has a lot to say, although it doesn't frame it specifically in terms of judicial notice. It has a lot to say about how common sense perceptions about how people behave and how the world works feed into the judicial fact-finding process. So we've integrated that into the chapter on judicial notice. I think it's something that obviously it's important for people arguing appeals against credibility findings in the trial court, but it's also important in terms of how you formulate your submissions to the court about what findings Justice Jones should make in terms of believing the complainant or finding that the accused evidence raised a reasonable doubt. When and in what circumstances can you rely on common sense generalizations about how people ordinarily behave? And Kruk has a lot to say about that. So I hope the book is helpful in that regard as well.
Yeah. No, I mean, judicial notice is a really interesting area. I tell you, when I'm asked just to, Your Honor, you can just say that this is true. No one would dispute this. That can be a tough call at times because it's questionable, right, how far a judge can or should go in that regard. There are some clearly documented areas that aren't disputed anymore. Obviously, what the Supreme Court decided in Kruk is essential to doing this properly now. But to bring this back to where we started, right, back to digital evidence, of course, I was asked recently in a case to take judicial notice of deepfakes and AI technology, and that it just exists. And we all know it's out there, and it's so easy to tamper with digital evidence. And I can tell you that I was persuaded by that and decided to do it. Time will tell if other judges agree with me or not, or as this continues to work its way through the court system. But if you're going to ask the judge to do this, just make sure you've got the case law on your side to convince me that it's appropriate.
Or the book.
Oh, yeah, well,
And so we've covered some of the most, let's say, hot topics and evidence, but obviously the book is very voluminous. So these are not the only chapters in the book. There are so many other chapters that are more specific to other evidentiary issues. And I recommend everyone to get a copy of this book because it is really a very important tool, and it's written in a very easy to read way. It's a very user-friendly kind of manual, which is not usually the case for evidence books. I have to say, I don't like to read evidence books. Usually this one is very different and it's modern. It really is what the name reflects, modern criminal evidence. Congratulations again on the second edition. There are some major updates and many of them are in the book. So thank you, both of you, for taking the time to do this evidence refresher for my channel. And I'm sure a lot of people will appreciate this. And hopefully I'll have you again soon to talk about the third edition when it's out.
All right. Thank you.
you.
Nice to talk to you.
Thank you.